Lisa and Jan and folks on the board asked me if I would come back and participate and do a session for you, especially on a topic that I'm really passionate about, and that is kind of the legal landscape and how do we take that, how do I take that as a non-attorney, right? So I'll tell you that up front, I'm not an attorney. And how do I take the guidance that I see in the law and in cases and what I talk with my colleagues about, some of whom are attorneys, how do I turn that into actual like best practice on my campus and in my program? And then how do I share that with other folks around the country so that we're making progress, we're making more pathways to access for students with disabilities. That's something that I'm really passionate about doing. So I appreciate the invitation, and I'm glad to be here. Now, I do have to amend that. Last year I did a virtual session at the virtual symposium, so in a sense I've been with you, but I haven't really been with you, and I'm really excited to do that. So in talking about this presentation for today, when I talked with Lisa and others about it, it's really about those foundational cases that inform this practice. So while there are a whole slew of cases that have come after some of these early foundational cases we're going to talk about, and we're going to talk about some cases from this year as well, we are going to sort of step back into the past a little bit, because so much of the foundation for best practices does come from those early cases. And I want to share with you what it is that I try to take out of those cases, and in particular, the way the court, right, analyzes the case that's in front of it to inform the practice sitting in front of me. What am I going to do in my program? Now, it's really important to remind you all, by a show of hands or raise your hand, if you happen to be a general counsel for a school. Okay, perfect audience. Because what I want to remind you is, none of you are attorneys. None of you, the work you're doing is, right, writing briefs or arguing cases in front of a court or presenting cases. You are doing the work of providing access. But this type of information and analysis is really helpful for you to guide what it is you're doing in creating those pathways to access and engaging with your academic community about why this is important or why this is required, or right, your understanding of the law and how it applies is really important and helpful. So just a quick caveat. I'm not an attorney. My brother, who is an attorney, would remind me of that in a nice way to remind me that I don't want to seem to be practicing law and getting myself into trouble, so I'm not going to do that. I'm going to let you know that up front. And the information here is just really informational, again, designed to kind of walk you through how this analysis can be helpful for us in the field. I work at a university, so all kinds of people like to call me doctor for some reason. I don't know why. My sister, who is a neonatologist, would heartily remind me that I am not a doctor. In terms of the PDF version of this information that I'm going to provide and make sure that you have, and you may have it already, but there was actually an update, like a little addition to this, because from the time that I turned these slides in to today, a new important case kind of came out of the court, a new decision, and I thought, ooh, I want to try and share this with folks at the symposium. So if you want to use this information around your institution to share with your colleagues, to talk about some of these cases and the guidance we get from that, great, please do. Please do not post this anywhere on the internet, right? I want you to have it as a resource for yourself, because many of the slides have a lot of information in them that I may not necessarily cover, but this will be a resource for you to be able to come back to and get some information. So I have some good news and I have some bad news. And everyone likes the good news first. And the good news is there are lots of cases out there that can provide us good guidance on best practices in providing access in health science education programs. Hooray, isn't that great? In undergrad, we don't always have a lot of great cases that we can point to and say, like, this went to the court. Why is that? Well, that's because you all get sued the most when it comes to these kinds of circumstances. Because, the stakes are so high for students, especially in graduate health science programs, that they're the ones that are likely to pursue their claims all the way through the court process. And let me tell you what, it's not an easy process, and you're going to hear some of that in the discussion after my presentation today. So this is especially true when the ultimate issue is that student's dismissal or removal from the program. Students have spent a lot of time, energy, effort, and money getting to where they are trying to go in their professional career. And again, there's a lot at stake, and so people are going to be more apt to really fight for their rights as they're outlined. So, right, these cases that go to a district court or get to the appellate court are more likely or more often going to be related to your programs. The likelihood that one of my undergraduate students who's pursuing an undergraduate degree in poetry or history, that their parents are already like, oh my God, history, what are you going to do with that? The chances that they are going to, take this claim that far are less likely. Because again, it takes a lot of time, takes a lot of energy, takes a lot of money. For those undergraduate students, by the time this gets through that whole process, they're probably, been in their work life for quite a while. So 4 key concepts that I really want to talk about today for you all to have a grip on are these essential features of what I see and the ways in which we can analyze cases. And they're about shaping your processes for creating approaches to disability access. So the first concept is qualification. What does it mean to be a qualified student with a disability? I know, again, after I talk, you're going to hear a panel that's still about this very old, should be settled question of who is an individual with a disability, right? Can't we get past that? But there is a next stage about who is a qualified individual with a disability and what does qualification mean? We're going to look at this idea of essentiality. What makes a program element or requirement essential? And we'll talk a little bit about why this term essential is important. We'll talk about fundamental alteration. Now, fundamental alteration is what's called an affirmative defense to a complaint or a charge of disability discrimination, right? Something that the school would argue to say, well, we didn't actually discriminate against this individual because what they wanted resulted in a fundamental alteration of our program. Well, what does that mean, and what does it take to get to fundamental alteration? And we're going to talk about the interactive process / individualization that should be happening on your campus, and why engaging in an interactive process is really a best practice in many regards. Right? This is really a key feature, and I think in many ways helps keep these circumstances and situations out of court, because it allows us to identify effective pathways to access that don't result in things like fundamental alterations. And we're going to achieve this goal, right, by reviewing key cases that illustrate the best practices in each one of these areas. So let's just take you way back. We're going to start with qualification. And if you're here and you haven't read or heard of Southeastern Community College versus Davis, I highly encourage you to go back and read that case, right? We're going to focus narrowly on what are the key takeaways and analysis that we can look at. But Southeastern Community College versus Davis is actually the very first Section 504 case that goes to the Supreme Court, and it's about a nursing program, okay? And, folks like me in an undergraduate institution that has a nursing program, still in lots of conversations over time with our nursing faculty. Luckily, we've seen a lot of progress in that area, but sometimes nursing faculty will go, Southeastern Community College versus Davis, haven't you read that? These laws don't apply to us. well, let's take a little bit closer reading of Southeastern and what it actually says. So this was actually a unanimous decision by the Supreme Court that provided a considerable amount of early clarification and insight into who is or who is not a qualified student with a disability. And after this, cases that follow this, that point back to or reference Southeastern, provide us even more guidance. So we can kind of follow the lineage and history of Southeastern to understand. But Miss Davis, let's talk a little bit about who she is, was a licensed vocational nurse, and she sought admission to the RN licensee training program at Southeastern Community College. Now, Ms. Davis was academically qualified. She met all of the academic standards that were set out for admission to the program, and she had a good record as a licensed vocational nurse. And she'd been working in the nursing field, and she wanted to improve her standing within that field and become a registered nurse. So she applied to Southeastern, and during an admissions interview, Southeastern discovered that she had substantial limitations related to hearing, okay? And at the school's request in this process, they asked Miss Davis to go to an audiologist, provide them some information about her hearing loss, and the audiologist concluded that she, quote, suffered from serious hearing disability, right? This was a bilateral sensorineural hearing loss, and that her lip reading skills would remain necessary for effective communication. So Ms. Davis had relied on lip reading skills in her professional and earlier educational career, because again, this was 1978, right? The regulations had only just been issued when it got to the Supreme Court about Section 504, and that's going to come into play here. So obviously, she'd been participating in her educational and professional life without benefit of some of these anti-discrimination laws. Now, there was an issue here, and that issue, or the problem at hand, was the RN licensure in North Carolina was very general, and it included an authorization to serve as a nurse in an operating room, in the operating theater. Still to this day, most of our nurses and most nursing boards around the country require that nursing degrees and licenses be very much a generalist license. Can't pick and choose sort of our area. And so part of this issue that faced Ms. Davis and Southeastern Community College to help try and figure out still addresses us today. But there was another important feature. Section 504, right, applies to entities that accept federal financial assistance. And in most cases, state nursing boards didn't accept federal financial assistance. And this was 1976, 77, 78. So there was no Title II of the ADA to enforce upon a public entity to say that you can't have admissions requirements or licensure requirements which screen out or tend to screen out particular groups of individuals with disabilities, right? So there was nothing necessarily to hold the nursing board accountable to these non-discrimination requirements. And at the time, and similarly today, although we have some advances, and we'll talk about those in a sec, doctors and nurses in the operating theater all wore masks that covered their face. We didn't have clear masks at the time, and it really made lip reading impossible. So a key thing to focus on in terms of gleaning guidance from these cases, because let me point this out at the top here. Each of these cases is very fact-specific, and it's very much the ruling addresses the facts and the specific circumstance of the case that's in front of the court. So it doesn't mean that the ruling in this case is going to be 100% generalizable, right, across the spectrum. It serves maybe as a precedent that we can look to, and it serves as some guidance we can use to understand how did the court analyze what was in front of it to make its determination related to the circumstance and the facts and the law. So that's why when I look at these cases, I'm really looking for what is the guidance. And oftentimes, in my opinion, the guidance is about process, process, process. What did you do and how did you arrive at the conclusion that you arrived at? That is oftentimes going to get more scrutiny than maybe the outcome. There are times when the outcome of your decision is going to be scrutinized, but a lot of times it's about the process. So it's not really much discussed by the court in the Supreme Court ruling itself, but Southeastern kind of won favor of the court because it did a number of process-oriented things in considering Ms. Davis's admissions application, right? It showed that it really carefully considered the circumstance. So before denying Ms. Davis admission, they interviewed and interacted with her, right? They asked to get some information from the audiologist. They contacted the state director of nursing, and the state director of nursing advised, Ms. Davis isn't even going to be licensable on the grounds of safety at that time. And remember, no ADA. They contacted other schools of nursing. What are your experiences with individuals who are deaf or hard of hearing as students in a nursing type program? And after Ms. Davis appealed her denial of admission, Southeastern actually assembled the full faculty to discuss what are some possible accommodations. And they again reached out to the licensing board to say, are you sure about that decision? And the licensing board said, yes, we're sure that we would not be able to license her. So the school again came to this conclusion that Ms. Davis was not qualified to be in the program, and she was denied admission, and so she sued Southeastern Community College under Section 504. Now, at the time, no one was really sure of the requirements of Section 504 related to qualification. The district court had found for Southeastern Community College, they supported their contention that she wasn't qualified. The Fourth Circuit on appeal had found for Ms. Davis, right? And that was part of why this reached the Supreme Court. Many of the basic issues related to Section 504 were still unsettled. And in fact, between the time that the appellate court made its decision and the case got to the Supreme Court, the 504 regulations were issued and shed some new light on the case that the other courts didn't actually have. So the question that was before the Supreme Court was, does it violate Section 504 to impose a physical qualification standard, or in this case, the ability to hear, on an academically qualified deaf candidate for admission to an RN nursing programs? And the sides in this case, right, presented two kind of extreme interpretations of qualification and what that meant. So Ms. Davis and her attorneys said, well, but for her disability, right, she would be qualified. And under that argument, they said, you have to waive anything that Ms. Davis cannot do because of her disability. So excuse her from surgical rotations, or, have people communicating in the operating theater with her remove their masks. Right? This but-for argument. And the school, on the other side, had also a very extreme argument, which was, well, she has to prove that in spite of her disability, right, she can still meet all of our academic and technical standards. So we're not required to excuse anything. And that Section 504 prohibits denying admission purposely, arbitrarily, or irrationally solely on the basis of disability, right? Not uncommon to our understanding of disparate treatment, right? Two similarly situated people should be treated the same. And the court, in a way, kind of said, well, we think the school gets closer to the plain meaning of what the statute requires, but they actually kind of went somewhere else. And Justice Powell wrote the decision for the court. And what Justice Powell did was chose a position that was somewhere between both of the sides, between the advocates and between the lower courts. And Justice Powell, fortunately, was able to rely on the regulations that had just been issued around Section 504, right? So in those regulations, there is a definition for a qualified student with a disability, and that is a handicapped person who meets the academic and technical standards requisite to admission or participation in the school's educational program. And Powell kind of notes in an explanatory note that the term technical standards refers to all the non-academic admissions criteria that are essential to participation in the program in question. Now, it's interesting because in Section 504, that term essential doesn't actually show up in the definition of qualified student with a disability. But the courts, right, were looking at other aspects of discrimination law and other cases that had come before that were mostly related to employment and racial discrimination at the time. And they engrafted, or they took this idea of essential requirements and they kind of put it into the Section 504 regulations to be a part of what was going to be assessed. So according to Justice Powell, all essential requirements may include the ability to accomplish a physical skill or task such as hearing. And the fact that, qualification may be related to the person's disability doesn't make it exempt, that requirement, from application as a qualification standard. However, the court said, mere possession of a disability is not a permissible ground for assuming an inability to function in a particular context, right? Assuming that because an individual has a particular type of disability, that they won't be able to be functional in that context. And further, that colleges and universities can't discriminate against the genuinely qualified applicants who, despite disabilities, can meet those qualifications that are legitimate and essential. So we're starting to see Justice Powell put in here words that maybe weren't in the regulations, but help to qualify this idea of the requirements and standards that a school may impose. Why legitimate standards? Because the court didn't really want schools to go back and put into place some standards that were just simply designed to keep individuals with disabilities out. You say those aren't legitimate standards. So precisely what he meant by essential and legitimate, we don't really know. But based on some other cases that had come before, as again, employment cases, we can make some connections. And in a case called Griggs v. Duke Power, that had been decided earlier, which is a racial discrimination case, the court had said an essential standard would be one that's reasonably related to the future success in the program of instruction or the performance in the career for which this person is employed or is training, okay? And an illegitimate standard would be one, like I just talked about, that's adopted just to screen out a certain set of applicants because we don't think they would be appropriate in this, to perform in this profession. And another non-essential or illegitimate standard could be one that, even if it's a long applied standard, actually had little or no relationship to future performance in the program. So maybe we've had this long-standing rule, but when you look at it in application, it actually doesn't have any predictive validity in whether or not this person would be able to engage in your program or perform well in the profession. So Ms. Davis didn't prevail, unfortunately, because absent what the court called a fundamental alteration, she would not be qualified. And this is part of why we're starting with this case, is because, right, we're going to talk about fundamental alteration in a minute. So the most important limit articulated by Justice Powell was this concept of fundamental alteration. And what he talked about was, Southeastern could let Ms. Davis just engage in all the academic portions of the program, but doing only the academic portions would not give her near the education that the program is designed to deliver, and as such would result in a fundamental alteration of the nature of the program itself. And the school is not required to go that far. Because their duty is of the school, right, in non-discrimination, doesn't include these types of major adjustments or lowering academic standards. But there's a really important insight here. This was 1978, and we were talking about a nurse who was severely hard of hearing. And at the time, there was no way for her to have effective communication in that particular aspect of her program. But even in that day, Justice Powell said, you know, technological advances can be expected to enhance opportunities to rehabilitate the disabled or otherwise qualify them for employment. Such advances also may enable attainment of these goals without imposing an undue financial administrative burden or a fundamental alteration. So here we are many years later, and do we have technological advances that in fact will allow people to have effective communication in those environments? Yes, we do. I see a lot of heads shaking yes. So, because my time was limited, and I'm already, going really long here, I wanted to provide to you access to other cases that speak to this issue and that in particular can address some of these technological advances. So I want you to be aware of and do a little homework. Similar cases about effective communication are out there. Argeny versus Creighton University, and you all know Michael Argeny, he's been here and spoken to you, and Featherstone versus Pac Northwest University of Health Science. These are really helpful cases that again can provide us guidance onto what are our best practice. So let's talk about the next topic, and that is essentiality, right? We heard about essentiality in Southeastern. Now let's look at it and where it went after that case. So we're going to talk about a case, Shake versus Texas A&M University College of Medicine. And part of what this case looked at was trying to understand, is the aspect, the requirement, the standard that this student failed to complete actually essential? And the standard in question is the USMLE Step 1. Now, if I was ahead, I'd have to explain all of what that meant. So I'm glad that you all know what the USMLE Step 1 is and what it relates to. So Mr. Shake was a student at Texas A&M College of Medicine. And during his time there, he developed a pituitary tumor, and that pituitary tumor prevented him from passing the USMLE Step 1. Now, interestingly enough, the pituitary tumor also started to create some behavioral issues that the school was seeing, and so they were a little unsure what was happening for Shake, and at one point, the college actually assumes that this is a psychiatric impairment, and part of the actions they take are related to that. So when he didn't pass USMLE Step 1, and he wanted some accommodation or exception related to that, the college kind of gave him two options. They said, you didn't meet this standard, we can dismiss you, or you can voluntarily withdraw from the program. We'll give you some time to get this sorted out, and then you can reapply for admission. Because actually, before the onset of the tumor and the impairments that Shake was experiencing, they did really well in their didactic academic classes and even in their clinical skills and settings. They were an excellent student. But this issue, as it developed, was really negatively impacting them. And again, the college kind of assumed that this was psychiatric, and at one point, the dean indicated that they were concerned that Shake was a liability for psychiatric reasons. So Shake withdrew. He followed their suggestion. He withdrew. But when he reapplied for admission on 2 occasions, he was denied admission each time. So Shake sued in federal court under Section 504 and Title II, as well as some other laws. Now, usually when these cases go to court, the first thing both sides do is they submit motions to dismiss, right? They say, court, there's no real issue here. This should just be decided, and as the school, you should defer to all of our decisions, and you should, grant us a dismissal of this case. Nothing happened here. And oftentimes, the plaintiff side will say, Your Honor, based on the facts of the law, you should just be able to decide that this was discriminatory, and so we shouldn't have to go to trial on these facts. Well, many of the cases we see will all hinge around this idea of the request to dismiss the case. So from both sides, we kind of know, okay, Shaik's an individual with a disability. He has an impairment that's in remission. That qualifies him as a person under prong 2 of the definition of disability, because by this point, his pituitary tumor was being treated and was not impacting him as much. But the court also said, in looking at the facts of the case, we think that Shaik could argue that his withdrawal was actually a constructive discharge from the school and not a voluntary act. They told him, we could kick you out or you could withdraw and reapply, but potentially a jury could be convinced they never had any intention of readmitting Shaik. So an interesting piece of this case was that Shaik didn't ever formally state that as an accommodation, he should receive a waiver or a postponement of this requirement for step 1 of the exam, or receive an extension or even readmission. But smartly, part of what Shaik and his team argued was, I didn't really need to ask for an accommodation because this requirement is not essential, and we're going to try to show that this requirement is not essential. So we talked about this before. Is essential part of the definition of qualified? Well, that 504 definition says with respect to post-secondary education, right, a handicapped person who meets the academic and technical standards requisite to admission or participation in the recipient's education program or activity, that's the definition of qualified. Essential is not in there. But the term qualified individual with a disability can also mean that an individual with a disability with or without reasonable accommodations or modifications to rules and policies and processes, right, can be a qualified individual. But they have to meet those essential eligibility requirements. So 504 maybe didn't have these terms, but as we saw the progression in the courts, we started to get this idea of essential being brought into the analysis. And in fact, the ADA kind of picks up on that. Where does it do that? It does that in an employment context. And because most of the cases that go before courts about disability discrimination are related to employment, the court starts to pick up this idea of essential. So in these pleadings for dismissal, what did the court find? Well, they found that it was plausible that the requirement imposed by Texas A&M wasn't essential. Now remember, because this is just a motion for dismissal, right? We're not arguing the facts in front of a jury yet. The court is deciding, has the plaintiff, who we need to assess the facts most favorably towards them, right, unless the school can absolutely refute them, has the person put forward an argument that a reasonable jury may be able to make a decision that they agree with that argument that the student or the plaintiff is making. So the court found, there's nothing on the face of this complaint and in the facts that establishes that taking the USMLE and passing it is an essential requirement, right? The college's demand that Shaik retake the exam during his leave of absence suggests that it was a requirement, but it may not have been an essential requirement. Well, how do we get to plausible? They said to Shaik, well, you can take this withdrawal and then reapply. They didn't say anything about you have to pass the USMLE Step 1 in order to reapply and be admissible. They said you just have to reapply. So if they were going to accept Shaik back, maybe it wasn't essential. And because Shaik plausibly argues that he satisfied the school's essential requirements even without a reasonable accommodation, right? He was doing well before, and he may well have been able to take the USMLE at some point, that this court didn't need to determine whether or not he could have satisfied the requirement with a reasonable accommodation in place, because essentially what we've argued is, there's that word again, this may, in fact, once the case goes to a jury, not be essential. Okay. So this is also a case that's a little bit about causation, and is this sort of solely about disability? Because Section 504 does talk about a qualified individual being discriminated against solely on the basis of a disability. And it's an interesting 504 complaint, because 504 may be a better tool with regard to some issues related to, say, damages, or it has higher education specific requirements, and there are some sovereign immunity questions which we won't get into now. So the majority in the court found that Sheikh may in fact also be able to show that he was not readmitted solely on the basis of his disability, right? And part of that refers back to the dean of admissions saying, oh, I think this guy is a liability for psychiatric reasons. And when we take that to a trial, that may be enough to convince a jury that in fact this decision was made solely because he had a disability and had nothing to do with his passing the USMLE Step 1 or 2. Now, I just want to quickly touch on some cases that address a particular type of essentiality, and those are surrounding surrogacy, right? So assigning another human being to meet an essential requirement of a program. And most courts find that surrogacy is not going to be a legitimate form of accommodation or a way for a student to demonstrate that they are a qualified individual, right? That they could meet those technical and academic standards for completion of the program. But that can be very fact-specific. And so it's really important to go through these types of analyses when we're looking at what's essential and what's not essential, if someone's qualified, right? Are these legitimate standards before we make that call? And I provided for you here 2 cases, each one that ends up in a very different place. McCulley versus the University of Kansas, where what McCulley needed in terms of surrogacy was determined to be a fundamental alteration of an essential element, and so therefore, right, McCulley wasn't qualified, versus Searles v. Johns Hopkins, which is actually an employment case that's tied back to education, which says another deaf individual, which says, well, what may be essential in functioning as a nurse is understanding how to respond in a situation, right? And being provided effective communication to understand what the circumstance isn't necessarily an essential function of the job. What is essential here? So in one case, surrogacy was out. In another case, effective communication was in a way seen not to represent that same type of surrogacy. All right, so this concept of fundamental alteration, what's that, and how do we get to that? Well, guess what? It's another medical school case. Wynn v. Tufts Medical Center. And Wynn v. Tufts really outlines for us a lot of good process that we can begin to implement. So Mr. Wynn was a medical student at Tufts. He had a very spotty academic record. He had difficulty with multiple choice exams. He was good in analysis, good in practical and clinical settings, but he was really weak in retrieval. And these weren't your standard, A, B, C, D, E exams. They were, A and D, but not E, B and A, but not C. Those types of really complex multiple choice exams. And so Mr. Wynn was at a point where he was being dismissed from the program, and in talking with the committee that was dismissing him or assessing his time at the school, they said, wow, maybe there's a learning disability going on here. And they sent Mr. Wynn for an assessment. The school did. They provided the assessment. And what does Wynn discover? He has a learning disability, which could explain his difficulties on multiple choice exams. He requested to take all exams in an essay format, no multiple choice exams. And Tufts looked at that and said, no, we can't do that. And in fact, they argued, hey, this is a fundamental alteration of our program. And there was a dilemma that this presented for the court in Wynn, and that was that the counsel for Tufts said, hey, you know, there are all these First Amendment precedents, and the practice of the court is to defer to academic decision makers around issues of the curriculum and pedagogy and how you teach students. And that's especially true in medical school. So, you know, members of the court, we think we're the doctors, you're just attorneys and judges, you should defer to us, and when we say this is essential, you should just say, right, we're going to take your word for it. But the counsel for Mr. Wynn said, well, if the court just accepts a school's conclusion or Tufts' assertion that this is essential, right, this is fundamental and essential, without any scrutiny by the court, then what's the point of Section 504 and the ADA? Right? Anytime a student comes to us and said they were denied an accommodation, the school could just say, oh, that's a fundamental alteration. You have to listen to us. Sorry, we're, out the door. So there was a key solution here that points us to best practice. And what the court said was, well, deference is earned through adherence to a diligent consideration of the request, of alternative means of achieving the fundamental program objective, and that diligent consideration results in a rationally justifiable conclusion, right? So, we all watch TV and see these murder cases, and we all know, beyond a reasonable doubt. That's way up here, right? That's a high bar. Well, reasonably justifiable, that's pretty low on the bar. But the court's saying, we're not just going to defer to anything you tell us because you are the folks running the school and the academic decision makers. You have to show us that you at least went through a process to establish that this was essential and to investigate how could we do this? What means are there for this student to achieve the program requirements if what they're asking for isn't something that we really feel we can do based on the nature of that requirement? And this comes from and then flows into a number of other court cases that you can go out and see how this analysis kind of gets applied. So what the court said in the first round, when Tufts came in and said, Your Honor, you need to dismiss this case, right? You need to defer to us. The court said, thus far Tufts' obligation was to demonstrate that no reasonable way existed to accommodate Wynn's inability to perform academically on written multiple choice exams, and that was a reasoned, right, conclusion based on real professional academic judgment and not just a ipsy-dixit, right, a kind of arbitrary, unsupported assertion that really the only evidence for it is because I said it, right? I made this statement. And what had happened in that first round was that the dean, in order to support their motion for dismissal, had provided a 3-paragraph description of why the dean felt like this was an essential program element. And the court said, this is just conclusory. There's no evidence that you considered any alternatives. And the rationale didn't address the specific circumstances of Mr. Wynn and what was happening within the program. So the court denied the motion to dismiss, and they actually directed Tufts to go back and reconsider Wynn's request through a specific process. They said, here's what we want you to do. And so here's the guidance, right? We want you to gather relevant officials, identify the objective of the requirement, consider the requested accommodation in light of those objectives, and then consider alternative means of achieving those requirements. You can consider the cost, the effect on the academic program, whether the accommodation would, right, be a fundamental alteration or lower that academic standard. And if you go back and you show that you can do that, you did that in good faith, we'll give you what they called qualified immunity, which is kind of an odd choice of words, but go back and perform this function and come back and tell us what you found. So Tufts does that. And the second time they come before the court, they get the deference that they had asked the court for. Not merely because they were the academic decision makers, but because they had now demonstrated that they reached a rationally justifiable conclusion that granting that request would lower the academic standards and be a fundamental alteration. They also showed that in documenting their process, this process wasn't just a pretext to discriminate and kick Wynn out, that they actually went through this process in good faith, right? They demystified their rationale. So, is their rationale ironclad? Probably not, but that's not what the court required. They said, show us that you diligently assessed this, gave consideration, and came to this reasoned conclusion before we will let you decide and hold for you that this is a fundamental alteration. And part of what the court took into account was that, right, Wynn never identified his disability until he was in the dismissal process. And through that process, Tufts actually did a lot to try and support Wynn. They sent Wynn for an evaluation, they engaged with Wynn, they thought through what would this accommodation mean and how could we provide for Wynn a pathway to access. And so with that, right, they were granted that deference. So other fundamental alteration cases to go check out, I included these two, Zukli versus the Regents of University of California and Wong versus the Regents of the University of California, because they're both against the University of California, they're both in the same circuit court, and they're decided completely differently based on the actions that the school took, right, in working through whether or not the student's request was a fundamental alteration. So you can see side by side how that analysis happened. So my last key area is the interactive process or individualization. And I want to focus on this as a best practice because a little secret, aside from Title I of the ADA, nowhere in Section 504 or Title II does it say anything about an interactive process. But almost all the court cases and every OCR case that you're going to read refers to the requirement for an interactive process. Now, who's right? I don't know, but I want to tell you this is the best practice, and I want to tell you why. Because it's about creating an individualized assessment of the barriers the student experiences in the academic environment, the physical environment, a virtual environment, your support programs, your other campus activities. Right, think back to what the court wanted in Wynn. Think about the student's circumstance. What did the court credit Southeastern for doing? Looking at the individual's circumstance. Right? And this is the way that we begin to understand what barriers that faces. Well, what else does interactive individualization process do? Well, it lets you look at the essential course and programmatic requirements. Look at the learning outcomes, look at the assessments that are used, look at the activities, the materials, the policies that you implement. By engaging in this interactive process and this individualized assessment, you're going to get a better sense of what are the issues that you need to analyze and work through. The idea of that interactive process does come from Title I, but again, OCR has really engrafted it, taken it and put it into the way they apply the law in their investigations. And the court has done that as well, especially in questions of failure to accommodate the students or other program participants. So why is this process so important to OCR and the courts? Because, to quote an OCR letter, Section 504 contemplates a meaningful and informed process with respect to the provision of accommodations through an interactive and collaborative process between the school and the student. Okay? It's about an engagement and a working through, that diligent assessment of what's in front of you. So here are a couple of quick cases that point to how this process gets applied and what the courts look for. And before I get into them, I want to talk about one thing. When you utilize this interactive process and you individualize, right, and you look at things like the essential elements of programs, and you consider whether or not a request would be a fundamental alteration, and you gather that group of relevant officials, 99% of the time, what you decide is, there is something we can do to provide this student access. In very few cases in my experience, right, from a practical level on the ground, have I come out of a meeting about a fundamental alteration where we've all gone, yeah, this is a fundamental alteration, and there's really no way that we can accommodate it. More often than not, what the interactive process winds up identifying is a positive outcome for the student, a way for them to be able to continue to participate and engage, to be qualified, and a positive outcome for the school to say, we feel good that we can maintain our academic standards and our essential requirements, and we can all move forward together. And that is a really key and critical piece about this being a best practice. So here's a case that's a place in which that wasn't necessarily applied. So this is Dean versus the University of New York at Buffalo School of Medicine and Biomedical Sciences. And Dean was dismissed from the program. It's a very complicated set of facts, and it's worth reading. And there was a grant of summary judgment in favor of Buffalo by a district court, right? The school said, please dismiss this case. They were granted their motion, and Dean appealed. And the Second Circuit Court looked back and they said, we think that the district court made a mistake. And we think that the school failed to show that that the accommodations that were requested by the student, Mr. Dean, were unreasonable accommodations, right? He was an individual with mental health disabilities, including depression, anxiety, and insomnia. And after failing to sit for and pass, guess what? USMLE Step 1, by the deadline that had been set up by the University of Buffalo, he was dismissed from the program. So the fact that he had a disability was not disputed. His disability impaired his ability to successfully complete Step 1. No one disputed that. Once he got onto a medication regimen, he was considerably better able to concentrate, prepare for, study for, and take the exam that he needed to take. None of that's disputed. What happened was that Dean requested, as an accommodation, a 3-month leave of absence to recover from the impact of his disability and to prepare for a third attempt to pass the USMLE Step 1. Now, Dean's doctor stated that he needed 6 to 8 weeks just for his prescribed medication to begin to take effect so that he could engage in these activities to prepare for the exam. And the dean, in Dean's case, a lot of deans flying around here now, denied this request, but provided an alternative and said, you know what, we'll give you a shorter leave of absence. Instead of 12 weeks, if my math is correct, yeah, we'll give you 8 weeks, which he alleged was not even as long as that what was provided to students without disabilities. That's what Dean, the student, alleged, right? His request was denied. He was offered 8 weeks, but Dean actually knew that other students who had made a request for an extension, students without disabilities, were given longer than 6 to 8 weeks that he was given. So assuming that Dean's doctor was correct about his recovery, that would have given Dean 2 weeks to study and prepare. So what did the court look at? They said, well, given that 8 weeks of leave appears to be ineffective, and it's less than what's received by other students who asked for an extension or a leave, and it's not individualized based on the information that was provided, absent some sort of affirmative defense by the school, right, it's a fundamental alteration or it's an undue burden, we're not sure that a jury wouldn't find that this is a plainly reasonable accommodation. The dean never engaged with Dean around this particular request and took many of the facts related to that request and didn't demonstrate that they had given them due consideration. So there may have been things going on below the surface. Maybe, they weren't happy with Dean as a student. Maybe they were wanting to see him dismissed. But it was the process and the lack of interaction and individualization that really got them hung up, because they couldn't show that they made a diligent assessment based on the facts in front of them when they were asked to grant this accommodation. So I'm not going to get to my 2022 case, but we will get to this 2021 case, and it's Kling versus the University of Pittsburgh Medical Center. It's a really interesting case because this is about a resident, and so there's some connections between employment and academia here. There's also a magistrate judge's ruling on this that goes into a lot of details that can be really interesting, and I'd encourage you to read it. But the district court upheld the magistrate's ruling to grant summary judgment to the University of Pittsburgh Medical Center in this case, right? So the school said, please dismiss. The magistrate dismissed. Mr. Kling appealed, and the court upheld that dismissal. So Mr. Kling's an individual with a learning disability, and after doing poorly in his plastic surgery residency, he was dismissed. More accurately, as residencies worked, he was going into his 4th year, and based on his performance, they didn't offer him a contract to continue into his 4th year. So you all know what that means, right? That's going to be pretty difficult. And there's this interesting intersection of employment and education. Is a resident an employee or a student or both? And in fact, the court here, right, analyzes this based on sort of an employment context. And in Kling's case, they said, well, to establish the failure to participate in an interactive process, which is required under Title I, they have to establish that the employer knew about their disability, that they requested accommodation or assistance, and that the employer didn't make a good faith effort to assist the employee in seeking accommodations, and that the employee could have been reasonably accommodated, but for the employer's lack of good faith, right, that didn't happen. And there's a couple of ways that employers can show good faith, and one is engaging in this interactive process, taking the steps necessary to meet with the individual, assess their circumstances, learn about their disability, consider what types of accommodations might be helpful in them meeting the essential requirements of their job or the essential standards of the program. And what the court and the magistrate found was that no jury could reasonably conclude that the defendants, the school, had failed to engage in that interactive process because they requested medical information from Mr. Kling. They had conversations with him. As they were making that analysis, they continued his placement, right, in a remediation program designed to help him get better. They had him undergo a neuropsych evaluation to understand his disability and the impacts of his disability. And they even allowed his annual review of his performance to kind of be stopped for the time being. And we'll pick that up back later if we can provide him some accommodation. And during his annual performance review, they seriously considered whether or not a remedial year in the program would benefit him in correcting his performance issues. All of which, the court said, was evidence that defendants engaged in the interactive process in good faith, right? So they actually spent the time and the energy and the effort doing this. Now, part of the issue for Mr. Kling was he was a plastic surgery resident, and one of the standards he had a really hard time was cutting in a straight line. So that was a bit of a problem. And that did sort of factor in, because in the end, what the court said was, we don't see how this learning disability is connected to his inability to perform this skill that he hasn't demonstrated he could meet at the standard that the program requires. Now I'm going to leave you, I know I'm a minute over, but I'm going to leave you with this interesting tidbit to think about. And what the Klain Court said was, as it relates to employment in a medical residency, as another court explained, a medical residency is primarily an academic enterprise. And it's distinct from other types of employment in that the resident's, quote, work is actually what's academically supervised and evaluated. So the primary purpose of a residency program is not necessarily employment or a stipend, but the academic training and the academic certification for a successful completion of the program. And if that doesn't leave you all walking out of here scratching your head saying like, uh-oh, what's our obligation there when our students become residents and we're still engaged in supervising them, then I don't know what would, because that's an interesting conversation. And with that, it's 5:02. I won't talk to you about Pickett versus Texas Health Sciences Center, which just came out in June, but I'll make sure the slides are there for you, and there is a reference to that. You can go back and read Pickett, a very interesting case that's about failure to accommodate, but also about plain old disparate treatment of individuals based on disability. Thanks all for your attention. Thanks for having me. And enjoy the rest of the day and tomorrow.